In the Supreme Court case in the matter of the interim independent 2011, at paragraph 86, positivist approaches, Article 1, the Constitution has in conviction. The Constitution has a most modern Bill of Rights that envisions justice-oriented state and society. The values and principles articulated in the preamble in Article 6 and in various other provisions reflect historical in building a robust, patriotic, indigenous jurisprudence. At paragraph 87, in Article 259(1), the Constitution lays down the rule of interpretation, or as in interpreting the Bill of Rights to promote A rights. Article 10 states clearly the values and the fault the registrar of political parties for not producing them. She could not produce what had not been deposited at the registrar of political parties. If it is true the UDM, PAA, NCCP, and MDG political parties had signed and deposited their agreements with the registrar of political parties, we are entitled to assume that they must have had in their possession copies of these agreements or evidence of the existence, and which they were under an obligation to exhibit in these proceedings. At the very least, the Speaker or Honorable Ichungwah ought to have exhibited these agreements, which the Speaker singled out as having been presented on the floor of the House during the debate. Without these post-election coalition agreements, the Speaker had no basis to disregard and dismiss the registrar of political parties' information on the membership of Azimio Coalition and Kenya Kwanza Coalition. For the same reason, the Speaker had neither the legal nor factual basis of declaring UDM, PAA, NCCP, and MDG as having migrated from the Azimio Coalition and joined the Kenya Coalition Alliance. Again, the fact that there were pending disputes either in this court or before the political parties tribunal on the membership of UDM, PAA, NCCP, and MDG in the Azimio Coalition could not have been a reason for the Speaker to rule that the parties were in Kenya Coalition rather than in Azimio Coalition. Based on the information provided by the registrar of political parties, these parties were members of the Azimio Coalition, notwithstanding the disputes that were pending for determination. It was never suggested that the coalition agreements or agreements between the constituent parties were suspended or held in abeyance in the event of a dispute on the membership. Neither was there any suggestion or evidence that either this Honorable Court or the tribunal before which these disputes were pending for determination had stayed or suspended the coalition agreements pending the resolution of this dispute. It follows that by assigning to Kenya Kwanza Coalition, the Kenya Kwanza Alliance, the 14 members of the National Assembly elected under UDM, PAA, MCCP, and MDG party tickets without any justifiable cause or reason, or in the process declaring Kenya Kwanza the majority party in the National Assembly, the Speaker acted arbitrarily and violated Article 108 of the Constitution. I'll hand over to my brother to continue from there.
Until after the first elections, subsection 3 says, until after the first elections under this Constitution, subsection 2 shall apply to the Prime Minister. Guided by the canon of interpretation, expressio unius exclusio arterius, the expression of one is the exclusion of another, it is our finding that the listing of the category of public officers who can be members of political parties while conspicuously excluding the Speaker is not, does not exempt the Speaker, does not exclude the Speaker from the category of public officers who should not be members of political parties. It is our humble view that this omission is not by accident, but is deliberate act of Parliament to protect the office of the Speaker from political affiliations and safeguard its neutral law in execution of constitutional mandate as a guarantee of parliamentary independence. To further augment our findings above, we are emboldened by Section 23 and 24 of the Leadership and Integrity Act, which was enacted to give effect to Chapter 6 of the Constitution. The two sections provide as follows. Section 23 on political neutrality. An appointed state officer other than a cabinet secretary or a member of a county assembly shall not, in the performance of their roles, A, act as an agent for or further the interests of a political party or candidate in an election, B, manifest support for or opposition to any political party or candidate in an election. An appointed state officer or a public officer, and I think this is now the overriding one, an appointed state officer or a public officer shall not engage in any political activity that may compromise or be seen to compromise the political neutrality of the office subject to any of the laws relating to elections. Subsection 3 says, without prejudice to the generality of subsection 2, a public officer shall not A, engage in the activities of any political party or candidate or act as an agent of a political party or candidate in an election. Publicly indicate support for or opposition against any political party or candidate participating in an election. And then Section 24 is on impartiality. A state officer shall at all times carry out the duties of the office with impartiality and objectivity in accordance with Articles 10, 27, 73, 2b, 2 of the Constitution, and shall not practice favoritism, nepotism, tribalism, cronyism, religious bias, or engage in corrupt or unethical practice. It is instructive to note that Section 23, subsection 2 of the Leadership and Integrity Act applies to all public officers and also appointed state officers, subject to any law relating to elections. In our view, the only exemption provided for in law is a category of state public officers enumerated in Section 12, subsection 2 of the Politicals Act, to which the Speaker does not belong. We thus hold and find that the simultaneous holding of the position of the Speaker with that of leader of a political party and the leadership positions in the ruling party coalition, as in the case with the current National Assembly Speaker, Honorable Moses Wetangula, who is the leader of Ford Kenya and holder of key position in Kenya Kwanza coalition, reasonably evokes appearance of bias and undermines its neutrality role as the Speaker of the National Assembly and the independence of Parliament as a symbol of democracy, negatively impacting on our democratic standards as envisaged by the rule of law principle under Article 10(2)(a) of the Constitution. This dual role is therefore unlawful and unconstitutional. The other aspect of the Speaker's office, which the petitioners urge before us, is whether the Honorable Moses Wetangula was validly elected to the office. We hold that the Speaker was elected in accordance with Article 106, sub-Article 1A, and the Standing Orders 4 and 6 of the National Assembly Standing Orders. The fact that he was a party leader at the time of his election could not invalidate his election. However, for reasons we have given, his position as a leader of Ford Kenya, or a leader of any other political office or organ, for that matter, became untenable and inconsequential the moment he assumed the office of the Speaker of the National Assembly. He could not, and he has no capacity to perform any other functions as a leader of a political party or a political party organ as long as he is the Speaker of the National Assembly. Before we conclude, we note that 2 of the interested parties filed cross petitions. Under Rule 15, Sub Rule 3 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules 2013, it is only a respondent in a constitutional petition who has a discretion to file cross petition. The rule reads as follows. The respondent may file a cross petition which shall disclose the matter set out in Rule 10, Sub Rule 2. Going by the express provision of this rule, an interested party does not enjoy that advantage. It is presumed that an interested party has the option of and reserves the right to file its own petition. If the court finds that such a subsequent petition raises common issues as in the pre-existing petition, it may exercise its discretion under Rule 17 of the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules, and consolidate the petition. This rule reads as follows. The court may, on its own motion or an application by any party, consolidate several petitions on such terms as it may deem just. For these reasons, we are not inclined to dwell on the cross petitions any further, except to strike them out for the reason that they are misconceived and an abuse of the due process of this honorable court.
All right, so it is hereby declared that the question as to which party or coalition of parties is the majority in the National Assembly in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general elections. 2, it is hereby declared that the Honorable Speaker's ruling or determination contained in his communication from the Chair made on 6th October 2022 on the majority and minority in the National Assembly violated Article 108 of the Constitution, and therefore it is null and void. 3, it is hereby declared that the Honorable Speaker's ruling or determination from the Chair on 6th October 2022 with respect to leadership of the National Assembly on account of his determination of the majority party and minority party in the National Assembly is contrary to and violated Article 108 of the Constitution. To that extent, it is null and void. 3, an order of certiorari is hereby issued pushing the Honorable Speaker's ruling or determination contained in his communication from the Chair made on 6th October 2022 on the majority and minority party in the National Assembly. 4, subject to the foregoing orders, the rest of the prayers in the petition are declined. Parties will bear their respective costs. Those are our orders. I direct that you are at liberty, or the respondents are at liberty, to make a formal application for the court's consideration. Otherwise, we are not granting the orders of stay at the moment.
Yes.
Okay. So, on behalf of the petitioner and the interested parties, Law Society of Kenya, Katiba Institute, and Jubilee Party and Azimio Party, who are all interested party, we wish to do three things. Number one, to commend and applaud the decision of the three-judge bench of the High Court for upholding the constitution and integrity of multi-party democracy in Kenya. Because it is important that the judges have said the issues for who is a majority or minority was settled by the people of Kenya on the 9th of August 2022 through the exercise of their sovereign power. And you cannot have a greater blow for the constitution than such a finding that has been made, that the people of Kenya are supreme. Number two, it is obviously that over the last 2 years, the Kenya Kwanza government, using Ichungwah and other people in office unlawfully, has been running the government of Kenya contrary to the constitutions of Kenya, the injunctions in Article 3.2 of the constitutions. Therefore, once again, Kenyans will have an opportunity to have a National Assembly that has been established and is being managed and led in the manner that accords with the decisions of the Kenyan people on the 9th of August 2022. One of the direct implications of this would be that Kenya Kwanza, that believes in all kinds of taxes and oppressing the people of Kenya and abducting them, we now have a chance to ensure you have a parliament that can stand for the sovereignty of the people of Kenya and defend their interests. So that cannot be bigger than this as far as constitutional law goes. The issue number three, I believe my learned colleagues will pick the other issues, is the fact that we must continue to maintain faith that the constitutions of Kenya can be able to address injustices that are committed against the people of Kenya. I commend the parties here, Ken Njiro as a petitioner. I commend these other co-petitioners, Lempa and others who are not before the court, for taking up the issues with me a few years ago and asking, now that it would appear there is a problem in the decisions of the Speaker, is this a matter that we can be able to do something about it? I applaud them for being citizens of Kenya and taking seriously their duty under Article 3.1 of the Constitutions to defend the constitutions of Kenya. This also goes to Jubilee Party, that was an essential pillar of this particular case, to come and defend the constitutions and multi-party democracy. You will all recall the many decisions that have been taken to subvert Jubilee as a clear way to try to ensure that multi-party democracy is undermined in this country. And through a lot of resilience, through a lot of confidence and endurance, we can see light at the end of the tunnel. This will be a game changer, both from the standpoint of the law and the standpoint of politics. I believe Honorable Kioni would be in a better position to take what that means in those other sectors. But of Kenya discharge their responsibility by coming to defend multi-party democracy. So we applaud, and a representative of Law Society of Kenya is here for standing with the people of Kenya. We applaud all that. The gentleman here is called Peter Koira, appearing for the petitioners, together for Mount Kenya jurists, in order to protect the Constitution of Kenya.
Thank you. My name is Ken Njiro. I was the lead petitioner in this matter. And for me, what I have simply done is stood up as a citizen of this republic. One of the things that is demanded of me by this constitution is to ensure that it is upheld. And as that, this victory is a victory of the people of Kenya. What this victory is saying is that we must not allow anybody to subvert the constitution, be it parliament, be it the politicians, be it anybody who has been given an authority, any position of authority. So for me, I thank God for this victory. And I thank God for the continuation, if I may call it that, of the jurisprudence in terms of being able to protect this constitution and protect it through the rule of law. I think we're in a season where citizens are increasingly refusing to take things lying down, and I believe the leaders across the board who have been entrusted, and more so all government officials, or should I say, the Constitution calls them public officers, must understand that where they transgress the Constitution, we will stand in the gap. So for me, this is not necessarily the win for any political party or any politician. This is the win for the people of Kenya. And I urge people of Kenya not to allow their rights and their freedoms to be taken away by anybody who's been given any authority under this constitution. Asante sana.
You should have signed off by Ushen.
Denigrating the constitution and doing things that are against the constitution ni ushenzi. And we must ensure that ushenzi in all its characteristics, legal, political, and otherwise, must be defeated so that we have an Ungwana nation. Asante.
Thank you.
Stood firm on this issue and have continued prosecuting this case. Again, it's a very heavy team that had been sent here by the whole government and KK machinery. I want to thank the petitioners in the name of Jiru and Empa because they are the ones who initiated this. You will recall that from the beginning we started battling this issue as Azimio and UDA, but it is this team that decided to come to court on their own account, and I want to commend them because that's a good thing. To me, it should mark the end of political prostitution. What we have been going through for the last 2 years is just political prostitution. While my colleagues are hesitant to bring politicians into this, if our politicians who were elected by Kenyans remained faithful and had respect for Kenyans, we will not be where we are today. It is possible that we will not have lost the over 60 Gen Zs who were killed last year because of a terrible finance bill. If we had the correct numbers in the correct positions in Parliament, we hold that it is possible that we would have stopped the passing of that finance bill before it became what it eventually did, and we lost Kenyans. Again, there are very many pieces of legislation that have been passed. Those, to me, are also unconstitutional. And Wetangula, of all people, should have known better, and he should not have taken us through this kind of an embarrassment as a country. But the sovereignty of the people, supremacy of our constitution, and wanasiasa wajue, ukichaguliwa wewe haujaenda juu ya katiba na juu ya wale walikuchagua na juu ya vyama. You continue being faithful and obedient. You must remain within the law and do things as you were elected to do. Maintain the respect of Kenyan voters all the way, in and out of Parliament. I thank you.
That we are in, and Azimio is in, that part of Azimio is now in government. When it comes to reconstituting now the leadership in the House, what does it mean for us?
Well, it's quite untidy. How I wish that those of us in Azimio had the spine to withstand this tide, would have been able to put the country back on track. But I hope with under the chairmanship of Uhuru, because it's almost like him and I left studying in Azimio, pengine kitu itatokea.
But then again, what is unconstitutional, that has been declared unconstitutional, must be it doesn't matter how long it takes. It doesn't matter if it pinches you. So the Azimio people who had MPs who had shifted allegiance should deal with the consequences. Yeah.
There's something else I need to add. I think the official positions of Baba, the leader of ODM and the leader of Azimio Party, is that he donated some people to go and work for the executive of Kenya Kwanza. Now, as far he has continued to say that Azimio is part of that ODM, despite government, broad-based government, is still part of Azimio. So we expect Honorable Kalonzo Musyoka is there, Honorable Kioni is there, Wamalwa is there, the Azimio family is intact. But more importantly, I believe it has grown from the number of people who are there, because from Kenya Kwanza, Kenya has shifted from there. And I believe Kenyans are looking to Azimio to ensure that after it has gotten a majority institutionalized in the National Assembly, that we are not going to have this oppressive taxation, and we have a second chance to get rid of this affordable housing and these kind of crazy policies that are there, and to ensure that the national executive can now be checked. Parliamentary capture is a real problem in Kenya. Through this ruling, the issue has been addressed. Now we expect that when Azimio will be running the National Assembly, which is the most powerful organ of parliament, that now they can ensure there are no more abduction and extrajudicial killings of Kenyans. Because the state, what all that Ruto and his people, Wetangula, his conspirators were doing, was to ensure that you captured parliament so that they can commit all these atrocities that have been going on in Kenya. This we have a chance to address. Therefore, we expect that Baba, Uhuru, Kioni, and all the other leaders and Honorable Kalonzo are going to ensure now that institutionally they are more powerful, that the crazy manner in which Kenya is being run today stops.
This will actually start the process of actually moving out of that coalition. We've seen NAK Kenya Party start the process of moving out of that particular coalition. So if these other parties decide that the time has lapsed for us to be in a coalition, what then happens?
No. The decision of the court is the question was settled. It was settled on the 9th of August 2022. The people of Kenya decided who is the majority. You know, to move from your party or from your coalition, you actually need to resign. I do not see a single person resigning to do a by-election. More importantly, on that issue is this, that apart from the fact that you are not going to move out, it is an irrelevant issue. Elections, to mean anything, it means we decide everything on the day of the elections. Today, Ruto, I don't think he has more than 1 million of the voters who voted for him who are still with him. But he will remain president because of a decision made on 9th of August. So Azimio, irrespective of all this political prostitution that has been going on, those people, we shall now come after them. In fact, this is not the end of anything. We are now going after them now that IEBC is coming. This is just the beginning of tightening up the situation. Even Wetangula is not off the hook. Wetangula, they have just said he was employed properly, but they have said the speaker cannot be going after Ruto, saying Gachagua must go, and you are in the choir of the president. The ruling of the court simply means the speaker must be chosen to be a member of Kenya Kwanza choir or to be the speaker who defends parliament. So this is just the start. It is not the conclusion of anything. So anybody who thinks that they will continue prostituting with Kenya Kwanza, they are in for a rude shock.
But within 14 days, they are likely to appeal.
No, appeal they can appeal. They were there also in the Court of Appeal to try to stop this. I also commend the Court of Appeal because the Court of Appeal, when these matters went before the Court of Appeal said, no, Kenyans are entitled to have that matter resolved by the High Court in the first instance. You know, all that we are doing is this. The High Court has simply said that we have to run the Republic of Kenya in accordance with the Constitution, and expressly found that Wetangula thought that he could decide by himself that despite what the people of Kenya have decided, I can say who is the majority. The High Court has just said you had no power to do such a thing. I do not see the Court of Appeal saying Wetangula had that power. So I think this is a done deal.
Maybe just to reinforces the minor care decision also, where the courts decided that the presidential elections are decided at the ballot. Yes. That is what was decided as far as the presidential election is concerned. The effect of this judgment is to say that the question of the majority is decided at the ballot. How anybody appealing that would expect to win, I cannot understand. We cannot allow situations where I vote, you vote, he votes, and then somebody else comes and decides this is what you intended. That is the intention of this court. So to answer your question, whether people cross or crisscross, the majority will still remain Azimio, as a principle. How they negotiate the political deal is inside there, that's another issue. In any case, they are collaborating. Some of them have been donated. That's another issue.
It's just like a normal, it's just in a normal marriage. Yeah. You are bound to your spouse, but nothing stops our spouse from being a prostitute after marriage.
There are no defections under our constitution. Once you've been elected on Party X or Coalition X on the 9th of the month of August 2022, all those people who've been playing all the games they've been doing, including the many cases that we have had in Jubilee, they were really showing contempt on the Kenyan voter.
Mr. Kioni,
yes.
Please, I want you to explain a bit about political prostitution, please. I came a bit late.
Political prostitution. It is this decision of having very many masters. Yata unajua umaraya ni nini? Sasa kwa siasa umaraya ni hiyo. Kuhamahama, kuhamisha kila kitu usiku na mchana. Kwani nini nyingine? Na hiyo ndio shida. Even now, even as we are talking about coalition after the messy situation that we are in, you can still see that prostitution, political prostitution, becoming part of our culture in our politics. And it's not a good thing. We need people who have integrity in the way they do things, privately and publicly.
Thank you.